Assalamualaikum and a very good day to everyone. First of all, we wanted to thank our commercial law lecturer, Madam Siti Rauda binti Ramli, for giving us the opportunity to present today. Our group members have choose jurisdiction of Shariah Court as our topic for presentation for our assignment 1. Before we begin, let me introduce our group members. Our group members consist of 5 persons, me myself, Shakina Nasuha binti Zainuddin, Amira Rashida binti Abdul Aziz, Aina Jahira binti Azhar, Siti Kalisa binti Eramli, and Akila binti Asmadi. Without further ado, let me continue with the next presentation. Our group presentation will be talking about 7 main points. First is introduction. Second is consequences of having multiple Shariah court system. Third is level of Shariah court. Fourth is civil jurisdiction. Fifth is criminal jurisdiction. Sixth is jurisdiction over Sharia offences and jurisdictional issue. And the last one is our opinion on the topics.
Assalamualaikum warahmatullahi wabarakatuh. My name is Shakina Nasuha binti Zainuddin, and I will be presenting first about the introduction to the jurisdiction of Shariah Court in Malaysia. First, we need to know that Malaysia uses dual legal system, which is common or civil law and Islamic legal system. There are 3 court systems in operation, namely the civil court system, the Shariah court system, and the native court system. The Shariah court system is one of the 3 separate court systems that exist in the Malaysian legal system. The Shariah-based system is Islamic, in which Islamic law is implemented in the country. We dig deeper into the history. Islam was brought to Southeast Asia and the Malay archipelago in the 14th century via trade and business through the port of Malacca, one of the earliest kingdoms in Malaysia. The coming of Islam to Malacca saw the beginning of attempts to introduce the Sharia and to modify the Malay adat, customs, law to accord with Islam. Under Article 121, Clause 1A of the Federal Constitution, exclusive jurisdiction in matters with respect to Islam, to Islamic law, is conferred to the Sharia Court. This means that the civil court should not interfere in matters which fall within the jurisdiction of the Sharia Court. This is to avoid any occurrence of overstepping the boundary of jurisdiction. Before the amendment was made to the Article 121, the parties unsatisfied with the decision of the Sharia Court brought their case to the civil court, and it was very unfortunate to the evidence the decisions made by former being overturned by the latter. Next, Malaysia has 14 Sharia court system. The main reason for this state of affair is the distribution of legislative powers under the Federal Constitution between the Federation and the states where Islam and Islamic law are state matters. Unlike the civil court system in Malaysia, which is federalized court system, the Sharia court system is primarily established by state law. Therefore, Islamic law in one state might differ from that one of another state. Since Sharia courts are established under the state list, states have powers to enact their own laws and procedural matters. The outcomes of this legislative power are the varied legislations, albeit slight, as well as the varied decisions of Sharia courts in the states of Malaysia. There are hierarchy of Sharia court, which begin with Sharia Court of Appeal, Sharia High Courts, and Sharia Subordinate Courts. Administratively, the Sharia subordinate courts in every state are bound by orders from the Sharia High Court. From my earlier presentation, we know that Sharia court system has a lot, which is a 14 Sharia court system. So I will be beginning my next presentation with the consequences of having multiple Sharia court systems. The first one is non-uniformity of laws, which means the law of Sharia court in one state might be different from that of another state. The second one is territorial limit of jurisdiction. This means that Sharia court in one state has no jurisdiction to hear and determine a cause of action which has accrued in other states. Next is territorial of limits of orders. For instance, Section 4 of the Islamic Family Law Federal Territory Act 1984 provides save as is otherwise expressly provided. This act shall apply to all Muslims living in the Federal Territory and to all Muslims resident in the Federal Territory who are living outside the Federal Territory. It can be seen from this provision that, apart from being a Muslim, being a resident of one state is a requirement for a person to initiate a case in the Sharia court. The next one is forum shopping. I will be taking the case of Aisha binti Abdul Rauf versus one Muhammad Yusuf bin one Uthman. In this case of Aisha binti Abdul Rauf versus one Muhammad Yusuf bin one Uthman, after the application of polygamous marriage was dismissed by the Shariah Appeal Court in Selangor, the husband filed another application in Terengganu, where he eventually succeeded in his application. This is the impact of the difference of requirements in both states in dealing with polygamous marriage, where the appellant succeeded in setting aside the application to contract a polygamous marriage by the respondent in the Shariah Appeal Court in Selangor. Dissatisfied with the order, the respondent filed another application in Terengganu, where he eventually succeeded in his claim. And then, the last one is, in this respect, what is crucial is that the order issued by a Sharia court in one state did not bind another Sharia court in other states. Next, I will be passing on to Kalisa for the next presentation. Thank you.
Assalamualaikum, I'm Siti Khalisa and I'm going to present the third point for jurisdiction of Sharia Court, which is the levels of Sharia Court. From the bottom, we have Sharia Subordinate Court, and after that is the Sharia High Court, and the above is Sharia Court of Appeal. So we'll start from the top. So Sharia Court of Appeal is constituted by the Chief Sharia Judge, who will act as the chairman of Sharia Appeal Court. And for the jurisdiction, we have the appellate and the supervisory and reversionary. So for the appellate jurisdiction, one may hear appeals against the decision that is made by the Sharia High Court or the Sharia Subordinate Court. It can also grant leave to hear any question of law of public interest, and lastly, an appeal shall be decided by the opinion of the majority, and that is for appellate jurisdiction. And the next one, which is supervisory and reversionary jurisdiction. At any stage of any proceeding in the Sharia High Court, if it appears desirable in the interest of justice, the Sharia Appeal Court may call for and examine any records in any matter. And the Sharia Advisory Court may do so either of its own motion or at the instant of any party, whether in a criminal or civil matter. In such case, all proceeding of Sharia High Court on the matter shall be stayed pending a further order of the Sharia Appeal Court. And now moving on to the Sharia High Court. The Yang di-Pertuan Agong may, on the advice of the minister and after consultation with the Majlis Agama, appoint judges of the Sharia High Court. Also, a Qadi may continue to hold office as judge of the Sharia High Court if had previously been appointed a Qadi under the enactment and was performing judicial functions on the commencement of this Act. So, for the jurisdiction, the Sharia High Court has three, which is the original, appellate, and supervisory and reversionary jurisdiction. And lastly, for the supervisory and reversionary jurisdiction, Section 51 of the Administration of Islamic Law Federal Territories Act 1993 empowers the Sharia High Court, either of its own motion or at the instance of any interested party or person, at any stage of any proceeding, to call for and examine any records of any Sharia subordinate court and give such directions as justice may require. Also, whenever the Sharia High Court calls for the records, all proceedings in the Sharia Subordinate Court on the matter in question shall be stayed, pending further order of the Sharia High Court. And lastly, for the Sharia Subordinate Court, under Section 44 of the Administration of Islamic Law Federal Territories Act 1993, the Yang di-Pertuan Agong may, on the recommendation of the Chief Sharia Judge, appoint from among the members of the General Civil Service of the Federation judges of Sharia Subordinate Courts. For the jurisdiction, it only has original jurisdiction, which is civil and criminal. For the civil, in its jurisdiction, a subordinate Sharia court may hear all matters that the Sharia High Court is authorized to hear. However, its jurisdiction is limited to matters in which the amount of value of the subject matter in dispute does not exceed 50,000 ringgit, or where the monetary value cannot be determined. The Yang di-Pertuan Agong may extend the civil jurisdiction from time to time by notification in the Gazette. For the criminal jurisdiction of the subordinate Shariah Court covers any offence committed by a Muslim, which is under the Administration of Muslim Law Enactment 1989 of Selangor, or any other written law prescribing offences against precepts of the religion of Islam. The maximum punishment for such an offence should not exceed 2,000 ringgit, or imprisonment for a term of 1 year, or both. And that is all for the levels of Shariah Court.
Assalamualaikum, madam. My name is Aina Jahira. So I will be presenting about civil jurisdiction. Civil is a case which is not included with criminal. So any other cases that is not criminal related will be in civil jurisdiction, which includes matters relating to the personal and family law of the Muslim in the states. Each state has its own law and for Sharia law. An action against unnatural offences committed by a Muslim is also brought into the civil court. Sharia court may hear and determine the dispute in any case which relate to as follow. First, betrothal, marriage, rujuk, divorce, or nushuz, or judicial separations. And next is matters regarding disposition or claim to property arising out of any of the matters relating to the relationship between husband and wife. Third, matters relating to maintenance of the dependent's legitimacy or guardianship or custody, hadanah, of infants. And next is division or claim to joint acquired properties, such as in Malay word it is harta pencarian. And next is wills or death bed gifts, marat of a deceased Muslim. Next, hibah or settlements made without adequate consideration in money or money was by a Muslim. And wakaf or nazar, division and inheritance of tested of or interstate property, determination of the person entitlement to share in the estate of a deceased Muslim or the share to which such person are respectively entitled. And next, declaration of that a person is no longer a Muslim, which is murtad, or changing religion from Muslim to like Christian or Buddha. And next is declaration of that whether a deceased person was a Muslim or not at the time of his death, and registration and adoption of child, and for matters relating. Lastly, other matters in respect of which jurisdiction is conferred by any written law in the states relating to the Islamic religion. And that's all for my part. I will be passing the next part to my next member. Thank you, madam.
So, I'm gonna explain about the criminal jurisdiction under Shariah Court. So, criminal jurisdiction is in the Shariah Court duly established by any law in a state and invested with jurisdiction over people practicing Islam are hereby granted jurisdiction over offences against Islamic precepts committed by people practicing that religion that may be prescribed by any written law. These offences includes any of the matters listed in the list 2 of the state list of the 9th schedule to the Federal Constitution. There are some of categories of criminal offence categories, which are matrimonial offences, offences relating to sex, offences relating to consumption of intoxicant, offences relating to spiritual aspect of Muslim communal life, offences relating to the sanctity of the religion, and miscellaneous offences apart from those mentioned. So all offences under Islamic law which before the commencement of this act in relation of the state of Peninsular Malaysia are which before the commencement of the Shariah Court in relation to the state of Sabah and Sarawak had been tried by any of the court aforesaid shall be deemed to have been validly tried as if jurisdiction in respect therefore had been conferred conferred on those court by federal law. So from the above, only a small part of the Islamic crimes and punishment are included under jurisdiction of the Shariah Court. That's all from me. Thank you.
Hi, I'm Akila Asmani. So next, I will explain the next point, which is point 4, jurisdiction over Sharia offences. Sharia court have jurisdiction only over Muslim in matters relating to family law and religious observance, and can generally only pass sentence of not more than 3 years imprisonment, a fine of up to 5,000 ringgit, and or up to 6 strokes of the cane. As we all know, there are 3 levels of Sharia court. The lowest is Sharia subordinate court, while the highest is Sharia appeal court. For the Sharia subordinate court has only one original jurisdiction that can be further divided into two: the criminal jurisdiction and the civil jurisdiction. The criminal jurisdiction of the Sharia subordinate court is that it shall try offences committed by a Muslim under the enactment or any other written law prescribing offences against the precepts of the religion of Islam, for which the maximum punishment does not exceed a fine of 2,000 ringgit or an imprisonment for a term of 1 year or two both, based on Section 47, subsection 2, paragraph A. Any criminal offences beyond these limitations will come under the criminal jurisdiction of the Sharia High Court. Meanwhile, for the civil jurisdiction of the Sharia subordinate court is that it shall hear and determine actions and proceedings as the Sharia High Court is authorized to hear and determine in which the amount or value of the subject matter in dispute does not exceed 50,000 ringgit or is not capable of estimation in terms of money based on Section 47, subsection 2, paragraph B. It should be noted here that the subject matter for the civil jurisdiction of the Sharia subordinate court is the same as listed in the civil jurisdiction of the Sharia High Court. Next, we move to the last point, which is under issues in Sharia courts. One of that is jurisdictional issues, civil court versus Sharia court. It has been said that Islamic law and the civil law exist as parallel system in Malaysia. The proposition, while attractive, is closely integrated in law. As it stands today, the administration of Islamic law is confined to personal law for Muslims, and the Sharia court is subordinate to the court established by the federal constitution and under federal law. There are a few examples where the civil court simply overruled the decisions of the Sharia court of where the rules to solve the disputes were largely prescribed in the Islamic law. This is due to the fact that the Sharia court decision historically needed to be enforced by the magistrate court, which is the lowest court in the hierarchy of civil court. This has deprived the Muslim from getting the right which they should be entitled from the first place. Curiously, yet interesting to be heard, some of the cases were presided by non-Muslim judges, which has destroyed the value of the Sharia in the Islamic legal system. The civil court have not only interpreted the Islamic law simply, but have also denied the opportunity for the Sharia courts to adjudicate upon the dispute accordingly. The best example to show the conflicting construction of Islamic law interpretation between the qualified Sharia court and the civil court in deciding case relating to Islamic religion matter can be seen in Tengku Mariam binti Tengku Siri Waraja and Anori, Commissioner for Religious Affairs Terengganu and Os. In this case, the question of the validity of wakaf made by the testator for the benefit of the family and relative was referred to the Mufti of Terengganu, who gave a fatwa which declaring the wakaf to be valid. The propounding parties then brought this case to the High Court, which decided that it was not bound by the fatwa issued by the Mufti earlier, showing that the power to decide on Islamic law appears to be with the civil court. In 1988, the constitutional amendment was being made. Through this amendment, a new clause 1A was inserted in Article 121. The amendment was made as an effort by the federal government to prevent overlapping and redundancy of jurisdiction between the civil court and the Sharia court in terms of conflict between the decision of the two courts. Subsequently, the effort seems to have not worked well. In Shahamin Faisal Kung bin Abdullah versus Asma binti Haji Yunus, the civil court ruled that the issue regarding the custody of the children in the case was within the jurisdiction of the civil court. Edgar Joseph G. stated that such insertion of Article 121 Clause 1A in the Federal Constitution did not set aside the Court of Judicature Act 1964, and therefore the jurisdiction of the Civil Court was still recognized to hear the case. In other words, the Civil Court jurisdiction was not excluded in hearing the case. It was quite shocking that the Civil Court did not recognize the jurisdiction conferred by the Federal Constitution, the supreme law of Malaysia, to the Shariah Courts through the amendment which has been made to the Constitution. However, in Muhammad Habibullah bin Mahmud versus Farida binti Datuk Talib, the Supreme Court did discuss on the issue of jurisdiction of civil court and Shariah courts. Since Muhammad Habibullah case, the later cases started to recognize the status and exclusive jurisdiction of the Shariah court in Malaysia. Despite the efforts to bring glory to the Shariah courts, it is undeniable that there are judges and writers who still not accept the special position of the Islamic judiciary system in Malaysia, especially regarding the source of interpreting the Islamic law and the procedural law provided under the Shariah court system. To ensure a good connection between the civil court and the Sharia courts, it has been suggested both court systems must work together. Yvonne Chu has commented that jurisdictional complexities should not obscure the fact that constitutional issues remain in the ambit of the civil court and that proper engagement by both civil and Sharia court is required to provide meaningful protection of the fundamental constitutional rights of the people.
As a conclusion, therefore, Islam provides clear guidelines and principles on the competition law and policy. Islam emphasizes on the physical and spiritual aspects in maintaining justice and peace amongst human beings as stipulated in Al-Quran and Al-Sunnah. We also learn that the jurisdiction of Sharia court is limited to Muslim only. Is only in respect of matter enumerated in List 2 of the 9th Schedule of the Federal Constitution. The Sharia Court criminal jurisdiction is only in respect of creation and punishment of offences against the precepts of Islam and insofar as conferred by the federal law. According to our understanding, the existence of the 14 Sharia court systems can generate issues in the administration of Sharia justice. The establishment of an apex Sharia court for the Federation may not solve all the problems, but it may help to decrease them in the long run. As a result, the establishment of an apex Sharia court at the national level in Malaysia must take into account Islam's position under the Federal Constitution. We mainly use the internet as our primary source of information for our references. We were able to find the article that helped us getting the key points of this presentation by using Google Scholar. That's all from our group. Thank you.